I will use the mic, because I think they're recording this, so they can use it against us later. Thank you for coming out on a Saturday night, spending your time working together with other patriots. A lot of what we're going to do tonight, is going to be give you information and a challenge. I have a couple of challenges, and we'll get to those. Last night I spoke in Bonners, and they didn't throw anything at me, so it must have been acceptable. And it was for Bonners. It was good. It was a good turnout. And I want to talk to you about the history or what was going on around the time that the Second Amendment was being debated in Congress, and how that is important to us today. At the time, it was just like today. We sometimes we think that it's a surreal time and everybody thought the same way, and there were no issues and no difficulties, and they just met in Congress and did wonderful things, and the country flourished. And I think they started going awry within 10 years, if not sooner. But there were enough of the original founding framers around that they were able to steer things back. And so that's what we have to do. There are people in here, many of you probably know a lot more about this Constitution than I do. And why you have me up here, but probably because I talk a lot. Here. So at the time that the Second Amendment was being debated, by the way, it was the Fourth Amendment when it started out. We'll talk about that when we get to it. There was swirling in the background, the Anti-Federalists and the Federalists, and some of the state legislatures had sent letters of recommendation after the Federalist Papers were written by the three men who wanted to encourage the states, the people, to encourage their states to ratify the Constitution. And so those were all written with that in mind. And there were people who wanted a Bill of Rights. They said, if you give us a Bill of Rights, we'll ratify your Constitution. There were people like Patrick Henry and Richard Henry Lee, Tench Cox, people back then who were well known, who were well versed in understanding how governments worked. And at the time, one of the big issues that was swirling was a debate, do we need a Bill of Rights? Why do we need a Bill of Rights? Now I'm going to give you some history. I'm not making any statements about whether we do or we don't. We have one. And we need to protect it. But at the time, in Federalist 84, Big Government Hamilton, how many of you are aware of the fact that at the time Hamilton would have been considered big government? Now today he'd be conservative, but he was big government in 1787. But he remarked that bills of rights are in their origin stipulations between kings and their subjects, abridgments of prerogative in favor of privilege, reservations of rights not surrendered to the prince. Such was the Magna Carta, obtained by the barons, sword in hand from King John. Such were the subsequent confirmations of that charter by subsequent princes. Such was the petition of right, assented to by Charles I in the beginning of his reign. Such also was the Declaration of Right, presented by the Lords and Commons to the Prince of Orange in 1688. And on he goes. He had a concern about a Bill of Rights, and I'll get to that in a minute. But a minute detail of particular rights is certainly far less applicable, he said, to a constitution like that under consideration, which is merely intended to regulate the general political interests of the nation. The general political interests. The intention, the full intention of the founders was that the federal government would be not very busy, ever. What happened? How's that working out for us? Then to a constitution which has the regulation of every species and personal of private concerns. The Constitution is pretty short. This has the Constitution, the Declaration of Independence, and jury nullification, the law of the land, jury tampering, a whole bunch of stuff. And it's a little tiny booklet, and that was their intention. That was their full intention. It was written to be fully understood by anyone with a reasonable education. And it was written so that we wouldn't need lawyers to parse it. And I think that's partially what has happened, if not mostly what has happened to us today. They parse it so bad that they've ripped all the petals off and flushed them down the toilet. I go further, he said, and affirm the Bills of Rights in the sense and the extent in which they are contended for are not only unnecessary to the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers which are not granted. We have to remember, and I know that you know this. Now, we've all heard the old saying, preaching to the choir. Well, sometimes the choir needs some encouragement, don't you? And some words of, well, I would want to say wisdom, but I'm talking, so you're not going to get that. The Constitution was a grant of power. It was not a restriction of power. If it was a restriction of power, it would have probably run to 30,000 pages. But a grant of power, the founders said, what powers are the nations, the colonies, going to grant to a new federal government? They were few and defined. There's 32 granted to the legislature, 13 granted to the executive, and 9 granted to the judicial. Back then. Back then they had 5 felonies too, and now there's about 37 million. So the concern was that if they created a Bill of Rights, that some demagogue would come along and say, well, that's not in the list, so you must not have that right. But that had never happened in America, right? Yeah. How has that worked out for us, unfortunately? So I'll leave off with Alexander Hamilton there. The other person, interestingly enough, who was very much against the Bill of Rights was James Madison. He said this, it has been objected also against the Bill of Rights that by enumerating particular exceptions to the grant of power, that's an important phrase, it would disparage those rights which were not placed in that enumeration. And it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government. And were consequently insecure. By the way, all of our rights are insecure if we, the people, don't secure them. This document is paper. It doesn't secure our rights. We have to. This is one of the most plausible arguments, Madison said, that I have ever heard urged against the admission of a Bill of Rights into this system. But I conceive that it may be guarded against it. It may be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the 4th resolution. So he made a deal, if you will, with the Anti-Federalists and with the state legislatures. By the way, so the 17th resolution in the state of New York's resolution was that standing armies are the bane of liberty, and men shall never be debarred the use of arms. Anybody recognize that in New York today? I mean, that's like somebody took all the anchovies off the pizza. I just made that up. Wasn't very good. We'll work on that. Many of the founders did not want a Bill of Rights. They correctly, now it seems, worried that such a list might be misused by future demagogues. The simple fact that the then contemplated Constitution was a grant of power was enough for them. Actually, in 1787, in June, Pennsylvania, at the Pennsylvania Ratifying Committee, that's what Benjamin Rusk went to do. He went to convince the ratifying committee that they didn't need a Bill of Rights, that the Constitution itself being only a grant of rights, that the federal government would never have the ability to usurp state sovereignty by sticking itself, imposing itself into power that it was never granted. They would never do that. Benjamin was a good man, but I guess they didn't know the kind of evil that could come. Or maybe they did, and they just hoped that the people would not fall asleep. If a power was not conferred, the created entity, the federal government, could not exercise it. There was no grant of power to the states, by the states, to the national government to have any say about arms at all. That's what the word shall not be infringed. That's what that phrase means. You can't touch the edge of it. You can't touch the edge of the ability to keep and bear arms. Much ink has been spilled and defending and excoriating this amendment. Pro, con. What did the founders mean? Was it a militia that they wanted to secure, a collective right? Or was it an individual right? Now, fortunately, we have the thoughts of the founders themselves to consult. Now, often I steal my own thunder by jumping ahead, but many of you have seen the argument, and it's a good argument, that the First Amendment says Congress shall make no law or abridging freedom of speech or the right of the people to peaceably assemble. Who's the people peaceably assembling? Us. We's the people. Good. Article 3, no soldier shall in time, Article 4, the right of the people to be secure in their persons, houses, papers, and effects. Who are those people? Us. Article 5, no person shall be held to answer for a capital or otherwise. Who's the person? Us. Good, good. You get the name. I don't do multiple choice. All of them were talking about people. Why would the second not be talking about the same people? And so that's one of the arguments you've heard. I'm going to give you a different argument tonight, right from the debates of the convention. What the founders were worried about when it came to ratifying the Second Amendment. They had concerns. We have the right to defend life and property. Oh, I got to back myself up a little bit here. The simple fact was that the then contemplated Constitution was a grant of power, and it was enough for them. If a power was not conferred, the created entity could not exercise it. There was no grant of power by the states to the national government, have any say about arms. For most, this was enough. But the outcry for a Bill of Rights was loud and concerted. So we ended up with a list of 10, eventually. And we'll talk about that in a minute, too. We have the right to defend life and property, both from the individuals, not contemplated by the, both from the individual's perspective, both from individuals, bad guys, robbers, not contemplated in the second, and more importantly, from the government. Now, I think the flyer says you're going to find, you probably already know this, but tonight we're going to talk about what the Second Amendment is really about, who it's supposed to be protecting us from. I think you know who it is. Can you edit that out, Christian? No, I don't want you to. Much ink. So between June 8th and August 19th of the year 1789, Congress deliberated over adding the Bill of Rights to the just ratified Constitution. James, did you know that? The very first Congress that assembled, Madison kept his promise. He didn't dilly-dally around. He did what he promised he would do. Madison rose and proposed the Bill of Rights only 3 months after the Constitution took effect in March 4th, 1789. Mr. Madison, this is from the House records. Mr. Madison rose and reminded the House that this was the day that he had heretofore named for bringing forward amendments to the Constitution as contemplated in the 5th article of the Constitution, Article 5. You're going to find out, too, that they were concerned about an Article 5 conviction coming in so soon. They didn't want it. Interesting, I thought. And then I lose my place. He addressed the Speaker as follows. This day, Mr. Speaker, is the day assigned for taking into consideration the subject of amendments to the Constitution. As I considered myself bound in honor and in duty to do what I have done on this subject, I shall proceed to bring the amendments before you as soon as possible and advocate them until they shall be finally adopted or rejected by a constitutional majority of this House. Originally, the Second Amendment was the 4th in the list of 12 brought forth that day. The first 2 amendments, number 1 was regarding congressional compensation, how much money they would make. They should have said $3 and made it perpetual, but they didn't. Actually, in 1789, $3 was a lot of money, so maybe 3 cents, 3 pence. Number 2 was, number 1 was the census, was regarding the census. Number 2 was congressional compensation. Neither were ratified by the requisite number of state legislatures. Thus, the 4th Amendment became the 2nd, which we have today. What were the concerns of the founders as revealed in the debates? Was the 2nd relegated to personal defense and food provision only? Did only militiamen have the right to bear arms? They contemplated this. They knew the demagogues in the future might even bring these kinds of logics, if you will, forward. In further defense of the original Constitution and of the honorable action of introducing the Bill of Rights, Madison eloquently spoke. He said this: "It appears to me that this House is bound by every motive of prudence not to let the first session pass over without proposing to the state legislatures some things to be incorporated into the Constitution that will render it as acceptable to the whole people of the United States." Now, who are those people? Very good. There will be a prize afterwards. Maybe. As it has been found acceptable to a majority of them. Because remember, a majority of the states ratified the Constitution, but there were 2 holdouts. And he talks about that. But later on, we talk about that. "I wish," he said, "among other reasons why something should be done, that those who have been friendly to the adoption of this Constitution may have the opportunity of proving to those who were opposed to it that they were as sincerely devoted to liberty and a republican government as those who charged them with wishing the adoption of this Constitution in order to lay the foundation of an aristocracy or despotism." They were being accused of passing the Constitution so that they would have an aristocratic government or a despotic government. That was the furthest thing from the founders' minds. They wanted to limit government. He was ardent in his desire to bring into the fold of supporters those anti-federalists who opposed the original Constitution, as well as the 2 states that were holdouts. He said, "I allude in a particular manner to those 2 states that have not thought fit to throw themselves into the bosom of the Confederacy They never used words accidentally. Madison understood the difference between a union and a federation or a confederacy. He understood that. So did everybody in that Congress. They knew. That's why the words United States in the Constitution are small u, small s. That's not an accident. The intention was to recognize sovereign nations came together and ceded a few powers to a national government to deal with the national scene. And that was it. And that's why the original idea was that the state governments would be busy little beavers, but the national government, they could go home at any time they wanted. There wasn't much for them to do. A few treaties, you know, don't build canals. That's not your purview. That's another one that happened, but we won't get into that. So, note his description of the new government as a confederacy. Definitions of words were important to the founders, and the differences between a union and a confederacy were well understood at the founding, and Madison himself knew well the distinction. Calling the Constitution a compact was equally telling. It was a document created by the sovereign states that specifically delegated some few and defined powers to a new national government and was of the legal type of contract between sovereign governments. The states were anxious to be sure they didn't lose any sovereignty that they had not expressly delegated to this new national government. And by the way, this ended up resulting in the 9th and 10th Amendments. So regarding the Second Amendment, back to this. Whose right to keep and bear arms or to protect? Understand that many petitions from the different states were brought, as well as lists from members of Congress themselves. What were the concerns of that first Congress? What was the real purpose of this amendment? Look at one of the first iterations, and you'll begin to understand some of the debate. The debate was funny. It was just hilarious. Some of the debate was delightful. These guys, they poked fun at each other on the floor of the House, and they were serious. Don't worry, I'm not going to go through all of this, but maybe I will. No, we want to hear Matt. Matt's actually the speaker. I'm just the warm-up. The right of the people to keep and bear arms shall not be infringed. A well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. Now, every single word in that Second Amendment, original Second Amendment, is very important. That's what they debated. This is what came to the floor, Madison brought to the floor, and this is what they were debating. Notice 4 things. The designation of the right as belonging to the people. Number 2, a militia, not a standing army, was considered necessary for freedom to be maintained. Number 3, country is the same as state. They were interchangeable terms. Read the Declaration of Independence. Actually, we will. I'm going to close with that because I can't say it better. So, I'm going to close with it, but I also stole my own thunder. Here it is. What is a state? From the Declaration of DOI, from the Declaration of Independence, from the DOI. We, therefore, the representatives of the United States of America in General Congress, assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by the authority of the good people. Who are those? Oh my, you guys are on a roll. Of these colonies, solemnly publish and declare that these united colonies, capital, are and of right ought to be changed to, I added that, free and independent states. That they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have the full power to levy war, conduct peace, contract alliances, establish commerce, and do all other acts and things which independent states may of right do. They understood what they were doing. They were declaring themselves sovereign countries. 13 sovereign countries. Did you know Idaho could survive just fine with what we have in our borders as a nation? It'd be no problem. We have everything we need. We have potatoes. What else do we need? Okay, those are the first 3 things. Number four about the original First Second Amendment. Religious scruples override militia requirements. Now, the militia was incredibly important. The Militia Act of 1792 was very comprehensive, but it was very important to the founders that religious scruples and conscience be observed. Did you see anything in that I just read, the Second Amendment, about hunting or self-defense mentioned against people? I thought not. Who were these people? Now, I talked about the normal way we get to that. And here's the way the founders, here's the debates that you can see who they were talking about, who they meant for people. Roger Sherman, he was the guy who came up with the compromise, the bicameral legislature, in June of 1787, when they were at a stymied standstill. The little states said, we don't have enough representation, and the big states said, too bad. So, Roger Sherman, I am willing that this matter be brought before the House at a proper time. I suppose a number of gentlemen think it is their duty to bring it forward, so that there is no apprehension will be passed over in silence. Other gentlemen may be disposed to let the subject rest until the more important objects of government are attended to. He didn't think a Bill of Rights was that important. Interesting. And I should conclude from the nature of the case that the people expect the latter from us in preference to altering the Constitution, because they have ratified that instrument in order that the government may begin to operate. That was Roger Sherman. Alexander White of Virginia. I hope the House will not spend much time on this subject till the more pressing business is dispatched. But at the same time, I hope we shall not dismiss it altogether, because I think the majority of the people who ratified the Constitution did it under the expectation that Congress would at some convenient time examine its texture and point out where it was defective in order that it might be judiciously amended. And I do not say this, he said, as it affects my immediate constituents, because I believe a majority of the district which elected me do not require alterations. But I know there are people in other parts who will not be satisfied unless some amendments are proposed. Who do you think those people were? Oh man, I've got the best class in the world. James Jackson of Georgia. Let the Constitution have a fair trial. Let it be examined by experience, discover by that test what its errors are, and then talk of amending. But to attempt it now is doing it at a risk, which is certainly imprudent. I have the honor of coming from a state that ratified the Constitution by the unanimous vote of a numerous convention. The people of Georgia have manifested their attachment to it by adopting a state constitution framed upon the same plan as this. James Jackson was worried about an Article 5 convention as well. And I could go into, I had to try to trim this so it's only 45 minutes. And Matt knows me, I never use a sentence when a paragraph will do. So it was a lot of work. Elbridge Gerry of Massachusetts. If in this conflict the advocates for a federal convention should prove successful, the consequences may be alarming. This was in 1789, and they didn't want another federal convention. Just create a list of amendments, send it out to the states for ratification. That's what we want to do. That's what they wanted to do. We may lose many of the valuable principles now established in the present Constitution. If, on the other hand, a convention should not be obtained, the consequences resulting are equally to be dreaded. It would render the administration of this system of government weak, if not impracticable, for no government can be administered with energy, however energetic its system, unless it obtains the confidence and support of the people. Yeah. Wow, you guys are awesome. William Smith of South Carolina. That, however desirous this House may be to go into the consideration of amendments to the Constitution in order to establish the liberties of the people. You can say it. It's like Sunday school. It's timid. There's nobody sitting in the front. Y'all Baptists? Okay. The liberties of the people of America in order to establish the liberties of the people of America on the securest foundation. Yet the important and pressing business of the government prevents their entering upon that subject at present. This is enough to show clearly, and there was much more, and I trimmed it. But you can go to the debates of the Federal Convention, you can go to the House records of the first Congress, and you can see the debates on this, and the humor, and we'll get to that, it was just hilarious. It was also the states, it was the people, it was the states. The right was and still is one held by people, individuals, not collectives such as a militia. Indeed, the first militias were composed of men who brought their own arms, military grade of the day. The first 17 cannon were given to the Revolutionary Army by farmers. Good grief. I'd love to have, well, no. I'd have to learn how to fly it first. Okay. With them upon joining. So the right is and always has been an individual right. It was not given to us by the Constitution, by the way, or any other document. It is inherent because you're breathing. And unalienable. It cannot be leaned. It cannot be taken away. You can't give it away. If you say, I abdicate my right to keep and bear arms, the rest of the government and people are supposed to say, sorry, put your arms down. But if you want to pick them back up, you can, because you can't give that away. Second question. What were the concerns of that first Congress related to this amendment? Interestingly, the debate did not consider types of arms. It didn't consider when arms should be borne. It didn't consider where. The three concerns were that, number one, no person with a religious objection could be compelled to bear arms. Some were for the idea of conscientious objectors being required to provide a proxy for this military service. That's why it said in their first iteration, in person. Because if they wouldn't come in person, there were those who said, you need to provide a proxy to serve in the militia. Because that's just the way it ought to be. Now, and we often think that everybody voted yes and everybody voted no on the bad stuff, and that's not how it was. It was just like our modern meetings. That concern fell. We almost had an amendment that required conscientious objectors to provide a person to stand in their stead. That fell by a vote of 22 to 24. Pretty interesting. When you read the debates, I do a series on I started a series. I kind of got sidetracked building a house like an idiot in November. But I do a series on the Constitution clause by clause taken from the debates, and it's just amazing. Number two concern. They wanted this amendment to properly remove the desire for a standing army, the propriety of such being universally rejected at the time. They called a standing army the bane of liberty. There's some people in here that probably have a good education. What does the word bane mean?
Downfall? Yeah.
Excuse me?
Downfall?
Downfall? Yeah, that's a good thesaurus word. Yeah. Another one? Enemy? The enemy of liberty. Now, I am not against veterans. You would just be veterans of the state militia. But I would allege that we would have gone through far fewer wars if the states were more involved. But that's another subject for another day. Federalist number 29, regarding the people's militia and their ability to match a standing army. Here's what he said. But if circumstances should at any time oblige the government to form an army of any magnitude, that army can never be formidable to the liberties of the people. Very good. While there is a large body of citizens, little if at all inferior to them in discipline and use of arms, who stand ready to defend their rights. Somebody said that Wisconsin alone has an army of 680,000 people every deer season.
That's right.
You know, go get them. Number three, that they wanted the Second Amendment to be, that it be a proposition, that the proposition would be a bulwark against tyrannical government and a standing army. They call it mal government, or I'm losing the term. I'm getting old. It'll come to me about 2 in the morning. Number 4, that the militia be well regulated. Now, back then, regulated meant something different than it means today. Today, when we hear the word regulated, we think permitted, licensed, and allowed by the overlords of our lives. It didn't mean that. But you know what they found out during the Revolutionary War? When a New York militiaman fell in battle and a Virginia militiaman picked up his equipment, couldn't use it. It was the wrong caliber. The clothing was different. The caps and balls were different. Everything was different. They wanted regular equipment. That's what made regular meant. That's part of it. The other was they wanted regular-made training made regular. And that's why they assigned the training to the states, with the federal government overseeing it very loosely, if you will. So that was number 3. Number 4, since the fundamental purpose, I want to read this to you, this quote, since the fundamental purpose of the militia was to serve as a check upon a standing army, that's what they said, it would seem the words, quote, well-regulated referred to the necessity that the armed citizens making up the militias have the level of equipment and training necessary to be an effective and formidable check upon the national government's standing army. It meant trained and appropriately and commonly equipped. When we attempt to meet the objections of statists, this is what we need to tell them. The people are us, not members of the militia, not a military service only. Note an opinion in 2001 which incorporated an opinion, and I'm not going to call them decisions. Courts don't make decisions. Kings make decisions. Courts give opinions. Note an opinion in 2001 acknowledging constitutions, state constitutions, and an opinion in 1822, Bliss versus Commonwealth. In a commentary written by Judge Garwood in United States versus Emerson, the United States Court of Appeals for the Fifth Circuit concluded in 2001 that, quote, there are numerous instances of the phrase bear arms being used to describe a civilian's carrying of arms. Early constitutional provisions or declarations of rights in at least some 10 different states speak of the right of the people or citizens. They added it in so nobody would make a mistake. To bear arms in defense of themselves or himself and the state or equivalent words, thus indisputably reflecting that under common usage, bear arms was in no sense restricted to bearing arms in military service. Now what can we do? I'm going to make it, Matt. I told you 45 minutes. What can we do? Now I'm going to meddle in your lives. But I'm good at that. Number one, support good advocates of the right to keep and bear arms in the national, and I would speak of the Gun Owners of America is one of them. I'm talking about groups. And the state, and I want to speak loudly about the Idaho Second Amendment Alliance. Greg Pruitt, you can friend him on Facebook, and he's working hard. And locally, I believe the NRA does good work. We've had some issues with them at the state and at the national level. I don't know what's going on at the national level. But locally, the NRA does good work. They helped build on Lake Street, the shooting range and the big shooting range up on Baldy. That money comes back to us. So that's one thing to keep in mind when you're screaming about the NRA hurting us at the state and national level. There's a lot of local guys that are working hard, and they're just keeping their heads down, trying not to be political and trying to train kids to be safe. And they're good. They're doing good work. Number two, challenge where and when you can any and all usurpations, including those that seem to be unrelated or unimportant. What's a usurpation? Unjustly taking, yeah, or taking the jurisdiction of something that you don't have. So, challenge all of them. The recent bump stock comes to mind. I had people in my store saying, well, they're junk, they don't work, and who cares? Yeah, they're junk and they don't work, but they're part of an arm. The government can't infringe. They can't touch it. Even the stupid stuff, they can't touch. Now, maybe you guys think there's people out there who know how to use them, and this guy just knew how to use it, he loved it. But that's fine. Doesn't matter to me. If it has to do with arms, they ain't touching it. Nothing. They get zero ability to touch anything. The federal government has no authority to infringe on arms bearing at all. Thus, anything associated with arms is off limits as well. This will prevent untenable precedents being set. Precedent is the bane of liberty, too. When judges and jurists and others will not go back to the original documents, but rather they just look at the last 2 or 3 precedents, I actually do a little PowerPoint on it. And there's carpenters in the room. My son-in-law is a marvelous carpenter. Let me ask you a question. 92 and 5/8 stud is for the walls of your house, right? So you cut one 92 and 5/8 and it's exact. And you throw your tape measure away. And you use that as the template. You lay it on the next 2x4 or 2x6 and you mark it and you cut it, mark it, cut it. You do that, and then at the end of the house, that one goes in because you want to leave a part of the original, and you take the last one you cut and pull it out. And that's the template for your next house. And you do that for 30 years. What's going to happen? House is going to get bigger or smaller depending on what you do with that line when you cut it. It's going to stop looking like the original house. You're not going back to the original, the tape measure. You're using a facsimile, a good facsimile maybe, but a facsimile. And slowly but surely, over the last 241 years, we have moved so far away from original intent that most people don't even recognize it, and they'll fight you on it. Okay, that's one of my pet peeves is precedent. Number 3. 1, 2, 3. I'm almost done. Train and be proficient in the bearing of arms with the attitude that the U.S. Constitution has so many built-in protections for our liberties that we will completely exhaust them first. We will do everything we can to work through the document that founders gave us first. And I'm of the opinion we haven't exhausted them. We just need to wake up some more people. We need some more pitchforks, we need some more tar, we need some more feathers. My daughter raises chickens, we'll provide the feathers. Number 4, seek and support true liberty legislators. And we have one tonight that's going to be speaking, probably the best state legislator in the United States. And try not to be single issue. Now, I know this is going to raise some iron. Don't be single issue. Well, all I care about is the Second Amendment. Folks, when a legislator seems good on arms but is bad or spotty on other liberties such as life or property, trust them to cave when the going gets hard on arms. Because their worldview is wrong. A worldview of liberty. That life is to be protected from the first second that it is conceived until the last breath it draws. That property is yours to use, and doesn't the Declaration say that governments derive their just powers from the consent of the governed? That's in there, right?
Yeah.
Do I have a just power to tell you how tall your deck can be before you have to put a railing on it? Do I own that moral power? Then how in the heck did I delegate it to my local planning and zoning?
That's right.
Really simple. But no, we need precedent. Okay. Trust them to cave when their overlords call in their number. They will cave on the important ones. Our rights are not the result of a document, nor of a congressional grant. They are liberties from God. They are natural, and they inherit to us because we exist, because we are breathing. Let us defend them with the First Amendment as we can, only resorting to the second when all proper, moral, and legal attempts have been exhausted. Thus began the unanimous declaration, now called the Declaration of Independence, and I will end with that, because I cannot say it better. I'm just going to read this and close. And I'm going to make it. We hold these truths to be self-evident, obvious, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and he wanted to say property, but there was a concern, so he said the pursuit of happiness, which works. Property is part of my, except why am I building a house in November? That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. You can only consent to the government powers that you have. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, this is very important, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shewn that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce them under absolute despotism, it is their right, it is their duty to overthrow such government and to throw off such government and to provide new guards for their former security. May God grant us the ability to maintain this government through the protections we've been given. Thank you.